Okay, welcome everyone to Estate Planning in Uncertain Times. Um, when I created this years ago, it did definitely seem like uncertain times, and I revamped it a couple times, including the title over the years, and it felt like it was time to circle back uh, to this title, Estate Planning in Uncertain Times. Someone just asked a question if we will be sharing the recording with those that have registered. Yes, uh, we can definitely do that. You should get an email after the webinar is over with a link to the cloud recording. So let's go ahead and dive in. Hopefully, some of you who saw this on social media saw these graphics. If not this time, then in years past, when I've done this seminar, I've used these graphics a few times. It's a common theme. A lot of people have said this in other capacities. The quote, and I've wanted to use it, but I just don't see how it fits. The quote from Mike Tyson: "Everyone has a plan until you get punched in the face." That comes to mind, but that doesn't really seem to fit here. These two quotes seem to fit much better. Just I think along these lines, I may as well throw this out there. I grew up in an older family. As a teenager and preteen, I saw a fair amount of death. I went to a fair amount of funerals, and I saw a recurring theme as a young child. And as I got older, the theme was more. I became in the middle of some of it, and that was essentially that those that had good plans, things seemed to go fairly smooth. There was not a lot of chatter. There was not a lot of drama for the most part. Things got done, and that was it. Things were handled well in advance, but that was not always the case. And there was, unfortunately, some instances where there was not good planning, and there was family heartache and drama, and that's a big part of why I do what I do. I was always interested in it before I could put my finger on it. But thinking back, I think that's just a big part of why I do what I do. So we're gonna go over some pretty basic stuff. We should be done within 30 minutes. A lot of estate planning to me, as a young lawyer, as even a law student, there was something about it that seemed, I don't know, complicated. Uh, Words that you don't use in everyday topics, concepts that you don't want to think about. Was That was a common uh, dynamic, um, and so I want to try to break through that uh, tonight and just kind of cover some of the basics and open it up for a little Q&A. Q&A is rare, so most it's in most of these webinars, I don't get a lot of questions. Certainly, uh, I understand that. If there's something specific you want to cover, we do offer a free consult after this for any attendees, so we can cover that. And that has happened in the few Q&As I've gotten. Some of them are just a little too complex or a little too nuanced or a little too personal, and I need more information, so it's just not a good format for it. But if you have something basic, by all means, please feel free to pipe in. Just some basics here. You're in the right place. I'm not a big read, PowerPoints and then just reading from the PowerPoint, but feel free to skim that real quick. My contact information, which hopefully all of you have now anyway from the emails and the social media posts, but there it is. Just quickly, some things that other lawyers and clients have said about me over the years. And thankfully, this is from years ago. So I'm grateful that the number of reviews has only increased. It's probably about double what it was here. But thankfully, the ratings are all still the same. So common pushback or objections, if you will, for a lot of people are these three questions here. And we'll touch on some of that as we go tonight. But you may be thinking some of these things. You may have thought them before. Totally normal. I have as well. And we'll go through that as we get through the presentation. So what happens if you don't have a plan? What's the big deal? What's the risk? We're going to cover that as well. Let's start with the overview of what are the main goals of estate planning. You want to be able to give the things that you have. That's the first thing that most people think about with estate planning, the stuff. You want to give it to who you want, the way you want, when you want. You continuing down the bullet points on the left side going down. You want to be able to make sure that you're being cared for as you get older. I visited with some family today in a retirement community, and having adequate planning to make sure those things are handled the way that you want. You may not want to be in a retirement community, for example, or maybe you do. That came top of mind today. You want to have peace of mind, knowing, of course, that your things are going to go for the most part the way that you would like them to go or the way you would expect them to go. And if not, at least you know in advance. There's a saying, trade your expectations for appreciations. If you expect something to go a particular way and it doesn't, that's generally the greatest cause or one of the greatest causes of stress, is that blown expectation or different result. So planning for these things minimizes that. You want to protect others, children, surviving spouse. You want to avoid probate. That is, other than number one, giving out stuff to the people I want, the way I want it, when I want it. Probate avoidance is a huge common theme that I hear from clients. And understandably, we do a lot of probate, and all of it could be avoided. And that's again, speaking of expectations, it's unnecessary to go through that, the time, money, expense, aggravation, complexities, when it all could have been avoided with some good estate planning. Charitable intentions is another goal, passing on values and ideals. That's legacy planning. We'll talk about that a little bit. Maximizing your assets, minimizing taxes, and protecting assets from creditors. So some of you that are attending may already have a will in place. And those of you that don't have a will, guess what? You actually do have a will, whether you think you do or whether you want to or not. And that's Florida intestacy law. That's the state's default plan. Why is this frozen? There we go. That's the do nothing. I often say to clients, you have the right to do many different things and a lot of different options, and doing nothing is an option. That is something, doing nothing. And if you do nothing, you have the state's intestacy plan. And there's a specific order, priority of how things get distributed. Any children that are 18 will take money outright. That could get lost in a divorce or could get lost to creditors, could be spent foolishly. A spouse could remarry and they could then pass, and all of your stuff would then go to that new spouse and potentially down the line to that other spouse's children that they may have had beforehand. A judge will decide who raises any children, minor children. A judge will decide who's in control of the children's money, and probate is guaranteed in intestacy. This is a common issue for some of our clients, those that have minor children, 50-50 for our client base, essentially, give or take. So this is huge. Who's going to take care of your kids? And this is something you can handle in good estate planning, a pre-need guardian. Otherwise, the court's going to pick it. And the guardianship process is complicated, rigorous, etc. Every expenditure requires a process. It's not remotely reasonable to on a day-to-day basis to live in that paradigm. And then, of course, there can be infighting. So you can name a guardian in a will, and you can name backups. You can also have a trustee to manage financial affairs until they reach a certain age. That's even after they're 18 and you don't need a guardian anymore. All right. So getting past minor children, now we're circling back into the stuff, the first thing that people think about with estate planning. And that's the obvious list. And we go through a list of things that covers all of this and more. I don't have Bitcoin in there and NFTs, but that is something I cover in all of our potential new client consults. We also cover firearms and accessories because there can be significant liability if you happen to have certain types of firearms that are passed down to next of kin and they don't have the appropriate licensing for it. Now all of a sudden they are committing a crime, and a major one at that, felony. So there are certain gun trusts under federal law that can be set up so that you don't have your children being susceptible to committing felonies just by having possession of certain firearms and accessories. So we cover all of that. We ask about all of that. This is a critical part of estate planning. I had a phone call today or yesterday, with a client who was asking about real estate and if a particular property would affect their existing trust. And it was actually today and yesterday. It was an ongoing dynamic with the client I spoke to twice, multiple times over the last 2 days. And the answer to that question is the existing trust is not impacted in any way, shape, or form unless the house is titled within the trust. And what does that mean? This is a very common misconception. Some lawyers will reference that I want to have the trust own my home, or I want to title the home in the name of the trust. Trust is a contract. It's an agreement. A contract does not own property. A contract can't sell property, buy property, etc. People do that. So that person in the name within the trust is the trustee. The trustee acts pursuant to the agreement. And we'll get to a little more specific as to who the players are, but the trustee is the person that has legal title. The beneficiaries on the trust are the person or persons that have what's called equitable title. So the trustee, think of them as like a placeholder, the flag bearer as to who legally owns the property, but they own it only pursuant to terms of the trust. So titling property is huge. Titling not just real property, any property, bank accounts, etc. If you don't title something within the name of the trust, which means titled to the name of the trustee as trustee for the trust, and there's a whole spelling, we cover this on page 1 of our trust, how you should title stuff. Then if you don't title that properly, then the trust there's no influence. The trust has no influence over that property. There's no ownership. The trustee doesn't have ownership of the property. The beneficiaries don't have equitable title. So titling of property is huge. And let's dive in a little bit as to some ways in which you can own property. Individually in your own name, jointly. Florida, we have a wonderful thing for property with spouses. It's a tenancy by the entirety. It's a very unique form of ownership where the marriage actually owns the property. You can do a lot with that in terms of asset protection and estate planning. And then there's by contract, and that's where a trust would fit in, or a life insurance contract. So then again, there is the last sentence. For trust, you generally need to title in the name of the trustee on behalf of the trust. All right. So what are the main options in estate planning? The two main paths that we talk about on a regular basis. One is a will-based plan and the other is a trust-based plan. And revocable. There's also irrevocable trusts, which is a whole nother thing, and that's for all different types. There's multiple different types of irrevocable trusts for different purposes. That's beyond the basics by a lot. So that's not something that comes up generally on a day-to-day basis anyway, and it's definitely a lot more than we could cover here in 30 minutes. But those are the two main things that come up regularly, these two options, these two paths. You really don't need to get too concerned about irrevocable trust unless there's a few different paradigms, the main one of which is you have assets individually over $15 million, individually or as a couple over 30. So the first path, last will and testament, better than nothing. You can name guardians, you can name beneficiaries, you can name your personal representative who's going to run the probate for you. There are some problems. Number one, probate. There's nothing in a will about incapacity. That only kicks in when someone passes. If you cross state lines, there's a problem because the law generally looks at where the person was a resident when they pass. So if you move, you generally got to redo the will. Not so much with the trust. There are ways in which a trust can continue, but when people move, we generally do redo trust. But there's a lot more leeway in that, at least in Florida law. Same thing with trustees, not just the grantor of the trust, but trustees. In a will, kids get money outright at 18. There's no control beyond that. And you can't do anything with it during your life. So the will is only for when you pass. Probate's guaranteed. We talked about that. The famous courtroom scene from A Few Good Men. Expensive, time consuming. It's not here, but within time consuming, I mentioned it in another slide. It's also can be complicated. It's public. Here's the expensive piece. Far more expensive than estate planning, generally. So this is a sample probate estate. Total assets, $4,750,000. I mentioned life insurance and 401k. If that was not to a minor, if that was to an adult, that would not be part of the probate. It would be an asset, but it would not be part of the probate estate. It passes outside of probate, those things. But the fact that it's a minor now, we have guardianship issues. So I just used that for the example, and I wanted to clarify that. So now we have probate estate. It's the only difference in these last two slides. Total assets, total probate estate, same thing. And then even at 1%, which generally it's not 1%, that's $47,500. And a good estate plan that could avoid all of that costs a fraction of that. Guys, remember Granny. So there it is, complex, public. You have to hire a lawyer in Florida unless you're the sole. There's a couple exceptions. One is which the PR is a lawyer. The other is, I think, if you're the PR and the only beneficiary. Otherwise, Florida law requires a lawyer for probate. One of the few areas you have to have a lawyer. So a will-based plan can be okay if you have a smaller estate, because at 75,000 or less, you can do what's called a summary administration, which is a lot easier and quicker than a full, what's called formal administration. Or the other option, possibly where will make sense, is if you know there's going to be people that don't get along, then I'm going to throw them into probate right out of the gate. Let them duke it out. Let them go before a judge before they start fighting at each other and making it worse. And then eventually there's a lawsuit anyway. Then I may just do a will only out of the gate, because that's going to get filed and people can lawyer up and do what they're going to do. It saves some time and money and aggravation, possibly, than dragging a trustee through the mud with a fight. That's extremely rare, of course. The better option generally is a trust, and a revocable living trust or revocable living trust. It's very similar to a will with some huge advantages. can name beneficiaries. You can change it just like you can change a will. You're the trustee. You have total control. Generally, the grantor is also the trustee in the beginning. The person that creates the trust is also the person in charge of it in the beginning. And the idea is you can retitle things. Now, this is case by case, and there's some things that you don't need to retitle into the trust, and we can get into that. There's a wonderful thing in Florida where you can uh, name a beneficiary in any bank account, or it's a transfer on death or payable on death provision. So you can create a trust, and then upon death, leave your bank account alone, because some banks want you to create new checks and new account number and a new PIN and a new debit card. You don't need to do all that. If you can just name that upon your passing, it'll go to the trust, and then all the trustee needs to do, or the successor trustee, is upon your passing, they show up to the court with a death certificate, and then everything gets transferred. And there's other ways to do this too, a lot of other ways, but that's one. And then the idea is, if whatever you want to avoid probate, you title in the trust, there's a successor trustee who takes control upon your passing or your incapacity. And there's no probate at all. Definitely not just for rich people. I think it's kind of the opposite as I thought about this. Revocable or revocable living trusts are used commonly. It's the irrevocable trusts that I would say are more for the ultra wealthy typically. And can be exceptions to that too. So it's definitely not a rich person thing only, quote unquote rich. I think of the quote from Bob Marley where they ask him in an interview, "Are you rich?" And he's, with disdain responds, "What do you mean by rich? Do I have a lot of stuff?" By that, no, I'm not rich. But then he talks about the family and the love and the experiences. And by that standard, he's very rich. Of course, he was rich in all aspects of the word, I think. So that's it. A trust is just an agreement that's been around for hundreds and hundreds of years, that's been tweaked by statute, but it existed in common law in Britain before there was a United States Constitution, before we had laws. It's not some big secret myth. It is interesting, and can get complicated, but by and large, the concept is fairly straightforward. So here's a very simple example. Bob has $100,000. He wants to leave it to his son, Fred, but he doesn't want Fred to get any of the money until Fred is 25 and Fred has graduated college. Well, you can't do that in a will. You got to do a trust. Can't have conditions in the will. Not like that, at least. So these are the roles of people in a trust: the grantor, the trustee, the beneficiary. Three main roles. You can have multiple grantors, multiple trustees, multiple beneficiaries, successor trustee, contingent beneficiaries. This is Harry and Wendy. They create a trust. They're the grantor. They're the trustees. And in the beginning, they're beneficiaries. It's for their benefit. You title things in the name of the trustee on behalf of the trust. And this is a great analogy to me. It's like a backpack. The trustee carries the backpack with all the stuff inside, and something happens to you and you're unable to manage your affairs, or you pass, someone else picks up the backpack. No probate. Now, you have to have stuff in the backpack. That's a black letter law. Trust never existed if there's nothing in it. So we have a provision when you're transferring $10 out of the gate just to avoid any possibility of that. Here's the titling. We talked about that. Trustee of the trust. You don't have to spend a bunch of time and money, complexity. So now I'm going to talk briefly about children's trust. big concern, giving money to children, even if they're older, 28, 30, they get sued, they go through divorce, and these things happen. And baked in with a trust, you can create creditor protection, asset protection for your children that in a way that you cannot create for yourself as easily. Once you pass, a revocable trust becomes irrevocable. And then there becomes asset protection for children. So just for this example, we have Denise and Sam. Denise gets married to Jason. They commingle and they get divorced. Jason now gets half. Could be avoided with the trust. Sam gets sued for leaving the water running. Same thing. If he has money outright, there's no trust. That's all subject to be taken away by creditors. Think of it like a tube of toothpaste. With the trustee, they can give out money. The standard generally is HEMS, HEMS, health, education, maintenance, and support. So you can dole out money for those things. You can make the provisions as liberal or as strict as you want. I have all kinds of different provisions that I've used, and I got a new interesting one today. So that's another beautiful thing with trust. You can get creative. As long as someone can understand what it is that you're trying to do, you write it clear enough, you can, there really is very few restrictions in some of these things that as to how you want a trustee to act to take care of a child or a grown adult even. It's called a children's trust, but this would apply to a child who is a grown adult as well. It's just a way of creating asset protection for them. So current, what's called basic exclusion amount, $15 million. There is no Florida death tax or estate tax. The gross estate includes life insurance. Probate does not, unless, of course, like I said earlier, it's the probate is to a minor child. These are the incapacity planning documents that we typically include with every estate plan. Power of attorney, that gives someone the ability to act on your behalf. A few things that are interesting about that. The durable power of attorney in Florida cannot spring. So you have to make sure you use someone that you trust. In other words, you can't have a power of attorney that kicks in once you become incapacitated. It's either effective or it's not. And a durable power of attorney means nothing when you pass away. What makes it durable? Why do we call it durable? Durable means it survives. If you become incapacitated, it still continues. You have to have special wording for that. Otherwise, a general power of attorney, a one that is not durable, will not continue to be in effect if you are no longer have capacity. But a durable power of attorney lasts through incapacity. Then there's the affidavit of the attorney in fact. That's under Florida law. Some unique issues there that I can cover in a private one-on-one or a private meeting or a private new potential client conference. Living will, that's where you are, God forbid, in a terminal condition, unable to communicate. That's a key part of that. Unable to communicate, you are on life support, and you're in a chronic state where the doctors have opined that there is no chance you will recover. You cannot live without machines, and most people will sign a living will that says, no, thank you. I don't want to be kept alive like that. Just keep me comfortable and let me go. Healthcare designation, that's where you cannot communicate and you want to appoint someone to make decisions for you. Unlike a springing power, unlike the power of attorney, the healthcare designation can spring into effect. And the second you can communicate to a doctor that there is no healthcare designation. The doctor ignores that. It's only when you can't communicate. HIPAA. So if you're doing incapacity planning documents and there's a healthcare designation, you also need to make it clear that the doctor can communicate to your healthcare surrogate. So that's what the HIPAA form is for. Otherwise, doctor might not be able to relay information to the healthcare surrogate so they can make an informed decision. And then the healthcare designation doesn't do any good. So you need both of those together. Some lawyers will put it all in one document. I generally don't, but they're still short enough and it's all together in a binder. So legacy planning, we include a journal. This is passing on your values, your memories. You may include pictures. You may record stories. That's Remento and Storyteller, some really interesting third-party apps that are coming out so that people can record answers to questions on video, and that you pay a monthly subscription for, and it lasts indefinitely to pass that down for generations. And how I wish I had that for the great grandparents that I am named after, and beyond, the family members that came, to this country that I, heard things about. And then even beyond that, I had an uncle that did a genealogy on my father's side, and it's just fascinating. So to be able to have the ability that this generation now has and beyond to record all of that, I think that's amazing. We also cover memorial instructions, that's burial instructions, digital assets, that's a huge thing. Who has access to your books, to your music, maybe to passwords, to photographs? There's so much there, and we have a way to help clients inventory that and pass that along. Gifts of tangible personal property, there's a way that we handle that. You're allowed to do that by separate memorandum and edit it later under Florida law. Okay, so next steps. First of all, I can't imagine not doing this with an attorney. I like to make the medical analogy. It's like operating on yourself. I couldn't imagine doing that. There's a saying for lawyers: if a lawyer who represents himself has a fool for a client. So even if you do your own estate plan as a lawyer, you have a fool. You're a fool. Is that how that saying goes? Um, and if you're not a lawyer, I don't. There is no saying. It's just not good. It's worse than a fool. So obviously, some tidbits here for finding the right lawyer. And you really need a team too, depending on what's going on. And you certainly should use, if there's a tax professional you're comfortable with, financial professional, et cetera, they should stay in your team. You shouldn't need to have to switch. And I'll go over all these questions with people as the ones that are important to them during a call or conference. The way we do it, we do our initial conference. We mostly don't charge for that. If things look good and I go through all the assets, and we spend some time going over everything and getting an idea of what they want to do, and then I can come up with a price. Most estate plans will do a flat fee, and I have a chart that I'll walk people through, and depending on what's going on. And then if we come to terms, then I'll send out a sign up package that can be done online from your phone. They can pay. We can begin opening a file, begin generating documents, and then there's a design meeting. I'll send out a link to schedule a design meeting. That can be in person, that can be via Zoom, that can be over the phone. We'll spend some time, depending on the complexities of the estate plan, anywhere from, could be 20 minutes if it's super easy, to an hour and a half for something that's a little more complicated or a lot more complicated. And then we start drafting, and depending on the situation, we can, put the pedal to the metal and start drafting immediately if there's an urgency. But typically, without the urgency, we're a week, 10 days, 2 weeks to getting first round of drafts. And lately it's been more like 2 weeks, just we've been busy, but a week to 2 weeks is generally how that goes. Then you get your drafts, you can review them, you can suggest edits. We typically send them in Google Docs. A lot of lawyers don't send drafts, and I just don't get this at all. At all. I mean, I know what they tell me why they don't do it, but I can't imagine doing it that way. So I send drafts, of course, and then I encourage clients to read stuff. You don't need to read everything. That's why you hired a lawyer, but at least read, you'll see provisions where you see who's getting what and who's the trustee and who's the successor trustee. You can confirm some of that stuff. And I can walk through it too if you need to. But then eventually we finalize and it could be some back and forth. Even the design meeting, there might be something, you know what, I want to sleep on it. And I may give you some feedback. It doesn't have to be all in one meeting. There may be more than one meeting. And then eventually we get a final set and we set up a signing ceremony. We offer to send a mobile notary to people anywhere. If you would prefer to sign remotely, if you want to sign in our office, that's fine. You want to sign at home, that's fine. We can send witnesses. We try to include all of that in the pricing. And then, yeah, we don't, for our flat fee pricing, we never upcharge for any of that. And then we have a system that's set up through MailChimp where once the file is closed out, you'll get an automated email with a link that, just, hey, touching base, it's been a year since we closed out your estate plan. If you'd like to set up a meeting, please reach out. Actually, I don't think the link is in the email. It just tells you to respond, makes it easy. And then if you'd like to set up a phone call or whatever it is, then we'll go forward. We'll do a free annual conference if you want. And then, of course, if there are changes that need to be made, depending on what they are, we'll come up with a fair price to adjust it as needed. And that'll be case by case. A lot of changes can be made with an addendum. You don't have to scratch everything. And a simple one-page addendum can fix a lot of stuff. We kind of have a rule of thumb. I've had this for a long time. I only want to help people. And if I'm not going to help you, I don't really want to take your case and I don't want to take your money, that's for sure. So helping generally means I'm providing some benefit greater than the amount you're spending. And that's fairly easy to quantify in a probate dynamic. I can calculate what probate might cost to your next of kin versus what you're paying now. And, including time and aggravation, it's almost always a no-brainer for just about everything. But we'll go through that case by case, of course. Those are the key docs in most of the revocable living trust plans. There's also a pet trust. The children's trust, number 2, that's part of the trust. It's usually not a separate document, but I just broke it out. Pet trust, same thing. If you have pets in Florida, you can create a separate pet trust. It can be part of the trust itself to designate, who's going to take care of your pets. Those things, if you have family and, close friends, that's easy enough. But there are situations that people don't have that and they want to designate a pet trust. And a pet trustee. And Florida law allows that. Generally, both spouses should attend. Definitely, I will not proceed with a design meeting without both spouses there. If you're married, that can create all kinds of conflicts and problems. But the initial call, I prefer to have both spouses there. But there are times when it just, okay, you want to, pick my brain about some stuff, that's fine. Then we'll go from there. So I'll bend on number 1 on initial conferences. And then, right, we'll review everything. I'll gather some information, decide if we're a good fit, and then go from there. And that's the link to the Calendly EMRPA/PNC, or of course you can email me. I think you can even get to that through Google. On my Google local page, there's a link to schedule a conference. If you book within the next 3 days and we proceed with an estate plan, I will gladly take off $200. Yeah, you should be a Florida resident. If you're not a Florida resident at the time you create the trust, that you need to create it where you are a resident. So the time of creation is critical for trust, where you live at the time of creation. Different than a will. Trust, that's the key. That's the key parameter. So these are just some of the things that I've heard over the years. And if you have any of those thoughts, I'd be happy to discuss it with you. Phone number, link, email. Okay. That does it. It's 8:41. Let's see if there's, and I'll leave open Q&As for a second. Contact info is still there. Let me go back. Whoop. Let's go back to this. So you have my contact info. And let's see if I have any Q&As. Any new ones anyway? Okay. I have a question from someone who I know is a good realtor asking about state doc stamps on the deed to transfer the house into the trust. That's a common way to say it, transferring the deed into the trust. I'll go with that. And the answer is you're paying doc stamps generally on $10. So no, it is nominal because we'll put consideration of $10. If you're the owner of the house and you're transferring to you as trustee of the trust, it's generally the $10 for the first page, $8 for the second page, and that's included. We don't charge extra for that either, by the way. We do include. Let me take that back. We do charge for a deed, and we also do a title search as part of the flat fee, but we don't charge extra for the recording. We just bake that in. And it's important to do a title search now, just in case there's an issue. I'd rather know about that beforehand than transfer it to be held in trust. And then all along, it's the wrong legal description that's in the deed that you already have. So we'll double check your existing ownership before we do it. We didn't always do it that way, but we saw some problems come up over the years and said, yeah, no more. Interesting problems that I never would have imagined happened, where the county missed something, a prior lawyer missed something, and yeah. So we're doing everything we can to make sure the existing deed to the property is good, and then we'll deal with it from there. Average cost of a revocable trust. Uh, I don't want to really say what the average is. We do have some baselines, but let's cover that one-on-one. Annual maintenance fee for trust? No. Someone asks, is there a conflict of interest to represent both spouses? Great question. And can a spouse do their own individual estate plan? So we do have conflict of interest forms that are part of our sign-up packages that we may have to use from time to time. If I see spouses are not getting along so well, and they may have some differences of opinion, I want to get that clarified, because generally speaking, I need a common set of instructions. I can't have spouse telling me something that's contrary to what the other one does, and we put together a joint estate plan, and someone is not getting what they want. So I have to withdraw in that situation if I can't resolve the conflict. So yeah, so that's conflicts can derail an entire estate plan. Individual spouses can do their own estate plan, but we have something in Florida called homestead. We have something called spousal share. So that can get very complicated. You can waive homestead, you can waive spousal share. And we've done that in certain circumstances, unique situation. So yes, generally speaking, both spouses together is a way to do this. Someone asked, give me an example of how a trust can protect investment, real estate, or business assets. So a revocable trust does not provide any asset protection generally while the grantor is alive. You would need to make it irrevocable to have creditor protections. That's a whole nother topic. We can talk about insurance, we can talk about LLCs. There's a few different ways that you can structure to protect a business investment, but a revocable trust is generally not one of them. But once you pass, then the trust becomes irrevocable, and now there is creditor protection for your beneficiaries. So that's a great question. Interesting topic. I've read some awesome stuff over the years, including a 900-page treatise by an asset protection guru. And I don't proclaim to be an expert at it, but I know a lot about it and I enjoy it. And that's something that comes up in conversations quite a bit. So if I do an estate plan now and I'm single, do I need to change it when I get married? You probably should. You probably should revisit it. And there's a very interesting case up on appeal presently with the interplay of that question. That was another question I just got. Great question. Huge current topic where the issue was that there was a ladybird deed. Now we're really getting off on tangents. A ladybird deed is a enhanced life estate. So a ladybird deed, you would um, say, okay, I have this property. I'm going to transfer it to so and so. I'll transfer it to Bob, let's just say, when I die, but I'm reserving for myself the right to sell it, mortgage it, do whatever I want. I can cut Bob out anytime I want. So the way that the lawyers have generally described that is Bob has a vested interest that's subject to divestment. His interest can be terminated by the grantor, by me in that scenario, saying, yeah, I'm just going to transfer it to myself. I'm cutting Bob back out. So ladybird deeds create some flexibility, whereas a regular life estate deed, there is no take back. There is no selling. If you do it, you need the what's called remainder man. You need Bob's signature to sell it, mortgage it, and so forth. So lawyers created this ladybird deed concept, and there's really no case law or statute that addresses it. And in this fact pattern that's up on appeal, the ladybird deed was conveyed to someone who, uh, and then the grantor passed away. The survivor, excuse me, after the grantor did the deed, he then got married. And now there was a fight between the spouse, because it was their homestead, saying, that's my house. I have a homestead right to that house. It should pass to me. And there's Florida law that says if you're married or you have minor children, you can't set up a will or a revocable trust for your primary residence. And if you do, the law is going to ignore it, and it's going to transfer as if it was intestate, with some exceptions. And that's a little complicated, but a little too complicated for this. But so the answer to your question is yes, especially in light of what's going on with that case on appeal. It's really highlighted that there can be complications if you have an existing will and you add someone. And there, by the way, there's a provision for that in Florida statutes too. A pretermitted spouse or pretermitted child, where you have a spouse after the will, and there's statutory scheme on that I'd be happy to walk through. I just walked through it the other day with someone else. Be happy to walk through that with someone over a call. All right, that's all we got for questions. Hope everyone enjoyed and got some good info out of this, and feel free to reach out. Thanks so much. Have a wonderful night, everyone.